Will deficiencies. The typical solutions to pass along your wealth has long been a will.
Some financial reports advise that annually as much as 53% of Americans die intestate without a will,
leaving their estates and thus their descendants to the not so tender mercies of the probate court. This is where blood is only sometimes more important than marriage.
Where state and federal tax authorities get to take big bites, where creditors get their money, where fees get paid to court-appointed executors, and the like.
Asset payout comes only after a great deal of time,
and according to state-mandated prioritized list of recipients. Sadly, even having a will does not solve the problem. All it takes to contest even the most carefully drafted will
is one aggravated person or another party, such as a charity named in the will,
to dispute anything from a minor clause to whether or not you were even sane when you wrote it. This challenge puts an estate into probate court,
where the wrangling can continue for years, sometimes to the limits of human and legal bill paying endurance.
The living trust is not exempt from this flaw. Although it could get around probate, it is treated the same as if a will was contested. Meanwhile, your estate's assets remain frozen. Also true if you died intestate, leaving your descendants with nothing until matters are finally resolved.
It was precisely to address this and other problems that trusts were created. When properly constructed and administered, they provide you with the maximum say over to whom your estate goes and how,
while maximizing privacy, protecting the estate, and minimizing the tax bite. Some forms of trust are more effective in providing these benefits than others, but all offer major advantages over the usual will.
In its simplest form, a trust is a legal entity created when you, known as the grantor, transfers ownership of personal property
to a trustee or a board of trustees for the benefit and support of the named party or parties, the beneficiary or beneficiaries.
There are two basic types of trusts, revocable and irrevocable, with many variations on each. In a revocable trust, you become the trustee and the beneficiary. You could change the provisions in the indenture until you die, but whatever the final version becomes, unless there is some gross legal defect, it is cast in concrete upon your death. It cannot be changed thereafter. Thus, a revocable trust becomes irrevocable. There is a big tax catch here too. If ownership of your estate does not change until you die, then while alive, you bear the burden for all the requisite taxes. In other words, personal control equals personal tax liability. In an irrevocable trust though, as soon as you sign and witness the carefully thought out trust indenture, for good or ill, not only are you committed, but likewise your trustees or your board of trustees and the beneficiary or your beneficiaries. Once the trust is funded, there is no turning back, and from this point on, while you have the use of many of the assets, you will not own them and cannot be taxed on them either. Why? They no longer belong to you. They not only belong to the trust, but are insured, maintained, and if necessary, guarded by funds generated from the trust.
While alive, you could enjoy some of the benefits of ownership with none of the hassles, while saving big on taxes and safe in the knowledge your estate will never be tied up in a probate court. Why? Probate has no jurisdiction over an irrevocable trust if it is properly drawn. Since the assets do not belong to you when you die, you have no assets to pass on. The assets are part of the trust, and the trustees continue to administer them whether or not you are alive.
Probate is about death, and an irrevocable trust lives much longer than the grantor.
Let's break this down. Your trust begins with you,
the grantor. For this example, we assume the initial corpus, literally the body of the trust, consists of $250,000 plus your $250,000 whole life policy, and say another $100,000 in mutual funds.
Depending upon the trust type, The corpus, which forms the assets of your trust, can come into being during your lifetime or through a will that automatically becomes into being when you die. This is a testamentary trust. Either way, the trustees administer the corpus and must increase the value of the trust, follow the terms of the trust indenture, determine investments, where to put the trust money and or assets to generate revenue, administer distribution, how much of the profits can be shared with the beneficiary, properly handle accounting to retain enough funds to cover expected administration expenses and keep enough funds to increase the investments. This emphasis on generating revenue from investments is no accident. Diligent trustees are all about growing the corpus. The more the trust makes, the more they make. Trustees, with the exception of the grantor, who usually acts as a trustee of a revocable trust, are paid a fiduciary fee based on a percentage of distribution. Through receiving a fiduciary fee, a trustee makes money if the trust makes money. If the trust loses money, the trustee receives either no money or less money. The ideal is to motivate the trustees to bring in the sufficient cash flow for the beneficiaries. Remember, your trust indenture must be written to provide not just your trustees, but their successors with clear-cut guidance on A, your intent, and B, what are and are not acceptable investments. If you found value in this content, smash the like button. Till next time, take care.